principal lawyer at Leo Lawyers, and just to be clear at the outset, although this looks and sounds like me, what you're watching is my AI avatar, presenting from a script that I've written and approved. One of the most common misunderstandings in contract law is this: people often focus on the breach itself, but overlook the legal consequences of how they respond to that breach. Today, I want to explain how termination, repudiation, and restrictive covenants like non-compete clauses actually work under Australian contract law, and why a single misstep can completely change your legal position. Let's start with essential terms and repudiation. Under Australian law, not every breach gives a party the right to terminate a contract. That right usually arises where there is a breach of an essential term, meaning a term that goes to the very root of the contract. The High Court in Kumpatu Local Aboriginal Land Council versus Sandpine Pty Limited explained that a term is essential if the innocent party would not have entered into the contract unless they were assured of strict or substantial performance of that obligation. Payment obligations are a classic example. In contracts involving share sales, business sales, or employment exits, payment of the agreed price is fundamental. If a payment that is due and payable is not made on time, that will usually amount to a breach of an essential term. That kind of breach often amounts to repudiation. Repudiation occurs where a party's conduct shows that they are unwilling or unable to perform their obligations under the contract, or that they intend to perform them in a way that is substantially inconsistent with the contract. Withholding a payment, especially where there is no contractual right of set-off, is commonly treated as repudiatory conduct. But here's where many parties go wrong. When repudiation occurs, the innocent party has a choice. They can accept the repudiation, terminate the contract, and claim damages, or they can affirm the contract and insist on continued performance. An affirmation doesn't require formal words. It can happen simply through conduct. For example, if you demand that the other party continue performing the contract, or seek specific performance after knowing about the breach, you may be taken to have affirmed the contract. Once that happens, you may lose the right to terminate based on that breach. This decision has significant consequences for restrictive covenants. When a contract is terminated for breach, both parties are generally released from future or executory obligations. Some clauses are designed to survive termination, such as confidentiality, governing law, or dispute resolution clauses. Restrictive covenants, however, are different. A non-compete or restraint of trade clause will usually not survive termination unless the contract expressly states that it does. Without a clear survival clause listing the restraint as continuing after termination, the obligation may fall away entirely once the contract ends. That can leave a party exposed, particularly in sale of business or employment scenarios where restraints are commercially critical. There are a few practical points to keep in mind. First, always check whether your contract contains a survival clause and whether restrictive covenants are expressly included. Second, do not assume you can withhold payment to protect your position. Unless the contract gives you a right of set-off, doing so is likely to be a repudiatory breach. Third, be very careful about how you respond to a breach. Your initial response can determine whether you preserve your termination rights or accidentally waive them. And finally, if you've already affirmed a contract, all may not be lost. In some cases, issuing a formal notice, making time of the essence, and clearly setting out the consequences of continued non-compliance can help restore your position. These principles apply across commercial contracts, employment agreements, shareholder agreements, and sale transactions. At Leo Lawyers, we regularly advise clients on termination rights, repudiation, and the enforceability of restraints of trade. If you'd like advice tailored to your circumstances, You'll find our contact details in the description box, or you can visit us at leolawyers.com.au. Thanks for watching.